Hello and welcome to the Arbitration Conversation. So in this episode, we're going to talk about intellectual property arbitration. And I have the real pleasure of talking to a true leader in dispute resolution, Mr. Theo Cheng. Now, what's amazing is that he went from being in private practice as an attorney and litigator to actually running his own dispute resolution firm, which is really impressive. I know a lot of my students, that's kind of their dream job. So, so Theo, congratulations on that alone. So he's also the immediate past chair of the New York Bar Association section on dispute resolution, as well as he heads up the president of the American Inn of Court for ADR, which is really cool. So thank you so much for being here, Theo.
You're welcome. Happy to be here.
So what we want to talk about is what is special, or why do you think, first of all, just from a functional analysis, why would somebody think about seeking arbitration rather than litigation if they do have an IP dispute?
Well, I think there are many advantages of actually arbitrating an IP dispute rather than trying to bring them into court. First and foremost is really the lower costs that are involved in arbitrating a matter. That's generally true of arbitration matters, but it's even more so with respect to intellectual property matters because, as any practitioner in the IP space knows, it's notoriously expensive to litigate IP matters in court. In particular, patent disputes, for example, we're talking millions and millions of dollars in discovery and then ultimately through appeals just to get to an end result that you can get to much, much faster and much less expensive in an arbitration forum. But besides the cost, it's really the flexibility of the arbitration form that allows you to take advantage of those cost savings. So you can tailor, obviously, the nature and design of the process to fit the dispute in question. More so is, and perhaps even more important in the IP space, is confidentiality. That again is general to most arbitration matters, and I don't want to get off on a tangent on the sort of misconceptions of whether or not confidentiality really exists or doesn't exist in an arbitration forum, but the fact of the matter remains that in IP disputes, confidentiality can be paramount. We are talking about things like trade secrets and other confidential proprietary information that most attorneys would like to simply cover under a protective order or confidentiality agreement in court. But the fact of the matter remains that once you get to a trial, it is a public trial. Whereas in an arbitration hearing, at least that portion of it will still remain private as long as the parties are in agreement.
Right.
Besides those two,
yeah.
I'm sorry, go ahead.
Oh, no, I was going to say, yeah, I mean, we talk a lot about, the differences between privacy and confidentiality in arbitration. Confidentiality being something you definitely need to contract for, but that privacy aspect really adds a lot more sort of enforcement to the confidentiality provision, as you mentioned.
Yeah, absolutely. And I think, one of the other ways in which you save costs, in addition to what I've discussed already, is really the availability of preliminary relief and also emergency relief. Now, all the providers now have emergency arbitrator type provisions now, including the AAA and the LCIA and JAMS and CPR Institute. But the difference here between what you can get in an arbitration forum and in a court forum are really different because, first of all, you have a situation where you can get a faster assignment to a decision maker. You're likely, and as a result, likely get to a faster decision. Secondly, it's going to involve less cost, not just the time, but less cost involved, particularly because the evidentiary burdens are different. As you know, in an arbitration setting, arbitrators are not necessarily bound to adhere rigidly to rules of evidence, and so a lot more can just simply come in and be considered by the decision maker, thereby leading to a faster decision. And more so, as in IP disputes, what's really particular is that the nature and life cycle of an IP dispute is once that injunctive, for example, relief is entered, that can lead immediately to a settlement. So, or if it doesn't, then you know right away what the dynamics are between the parties and the dispute in question. And the sooner you find out what that result is, the better off you are in terms of how to manage the dispute going forward. And arbitration, I think, allows you to get there faster.
Oh, yeah, I love that point because I think you can think about, well, the idea of using arbitration as part of an overall problem-solving strategy is fantastic. Great point. Another thing I was thinking about with IP in particular is arbitration it allows for you to choose an expert in the area. And a generalist judge might not have that same sort of expertise. I don't know if you want to speak a little bit about sort of ideas and your advice really for selecting an arbitrator in an IP dispute.
Oh, absolutely. I mean, IP disputes can come up in any number of industries, any number of business contexts, but the fact remains that it may be very helpful to the parties to have someone who has that kind of background knowledge. If you're going to rely a lot on norms in the industry or custom and practice in the industry, or if you want someone who actually just has the technical know-how to understand some of the expert knowledge and specialized knowledge that's necessary to underlying the IP that's in question. All of those things, sort of point you towards the sort of advantage of using arbitration to select the type of decision maker you want, rather than spending a lot of time and money educating a generalist judge who may have had absolutely no exposure to IP. And really, it depends, right? I mean, a lot of IP is brought in federal court, and maybe those judges have seen a lot of those cases, but you can have a trade secret case show up in a state court where they're not used to seeing that, and you can spend a lot of time on tutorials, trying to understand the technology, whereas in the first instance, you can select an arbitrator that has had that kind of background, either through schooling or through experience doing other cases like this. And that actually leads, again, to more cost effectiveness and more expeditious resolution of disputes.
Do you have any advice? One thing that often comes up when thinking about arbitrator selection, especially in an area like IP where you're dependent on the expertise, do you see in your practice, and do you have advice on whether one arbitrator versus having a panel of three is better?
It really depends on the nature of the dispute. It's always difficult to determine that ex ante, right, before the dispute arises. But I think in general, if you are talking about an area that's going to likely be complicated, that's going to involve a lot of highly difficult contractual interpretation, I have found in my experience that it is actually worth having a panel of three. I know there's extra costs involved and extra time, and scheduling can be a nightmare when you have counsel plus three arbitrators. But I do think it is worth it, because in those situations where I have sat in those kinds of cases, the fact that the deliberation, the quality and nature of the deliberation has been much more rich. Not to say that if you have a relatively straightforward case, like a licensing dispute, where it doesn't involve a lot of heavy understanding of IP law, for example, or contractual interpretation of terms and conditions, then a single arbitrator is perfectly fine. And it's, like I said, it's hard to tell on an ex ante basis. You can't even say that, well, if it's over a certain amount of money, because sometimes over a certain amount of money is just simply the failure to pay, and it's nothing more than that.
Right. We've talked a lot about the benefits of arbitration for IP, but what about the limitations? Are there certain cases where you think, this isn't really the right type of case, or maybe the type of relief you're looking for, that maybe arbitration isn't the right way to go?
I would love to tell you that arbitration is the best for every kind of dispute, but I must confess, there are some limitations. I mean, the one that immediately comes to mind, we just talked about preliminary relief. Like an injunction that's entered by an arbitrator really can only reach the parties that are before the arbitrator. And yes, maybe you can stretch it to cover people who are acting in concert with the parties in front of you. But one of the major things that people want in court is to be able to have a nationwide injunction that stops manufacturing or stops certain conduct well beyond the seemingly territorial limits of the court. That's just not possible in an arbitration forum, because arbitration, as you know, is creature of contract, has to be by consent of parties. So there's some limitations there based on the arbitrator's own jurisdiction. The second thing is, if you're looking for some sort of binding or precedential opinion coming out of an arbitrator, that's where you may be a little bit at a loss too, because while you probably are familiar with collateral estoppel doctrines that may stop relitigation of certain issues coming out of one arbitration into another, that is actually quite a patchwork of case law around the country, and it's not uniform at all. And for the most part, take, for example, a Markman hearing in a patent dispute. When you litigate that in court to finality, you are determining the rights and obligations and the metes and bounds of those claims for all time. essentially. And it has impacts in other related matters, parallel proceedings, and the like. In an arbitration setting, though, it can really only have an impact on that one case and on those parties. So if you are a party that's looking for finality in terms of what the claims mean so that you can have some peace of mind, unfortunately, you're not really going to get that in an arbitration setting, and you may have to relitigate these issues over and over and over again. And, you know, I think you could talk to different practitioners. Some actually like that because they don't want to have to be bound, and, you know, and they don't like the fact that arbitration is final and binding for the most part on those parties. But, you know, on the other hand, if you're trying to defend, I think you want some finality. If you've been successful in, for example, invalidating a patent or finding that the claims are outside a certain field or an area, you want to be able to hold on to that, and unfortunately you can't.
Right, right. It's kind of a gamble, right? You know, of course you want to have finality if you win, not so much if you lose, right? No, these are great points, though. I mean, I think for the most part, it definitely seems arbitration is a great way to go when you're looking at IP disputes, but it's also good to realize that there are limitations, especially on the injunctive relief and enforcement aspects. Because even if you do get a preliminary injunction or you get something through the arbitration itself, you still then have to bring that to court for enforcement.
Well, that's the other thing too, and that's where you may also blow your confidentiality, right? If you were counting on things to be confidential, that's all fine and well until you get to the court stage, and then of course confidentiality goes out the door because, you know, you can't really seal the underlying award from a court, generally speaking. And I neglected to mention one other thing, you know, when we're talking about court proceedings that's helpful in the arbitration context, and I forgot because I tend to be a domestic arbitrator. But in the international context, you tend to have a lot of parallel proceedings in multiple countries. And in those situations, the fact that you can arbitrate internationally and thereby eliminate sort of forum shopping and assure yourself forum neutrality actually is a wonderful plus to arbitration in the international space. And then coupled with that, of course, is, you know, the New York Convention, which allows you the recognition and enforcement nearly worldwide, which you cannot get if you're going to be in some specific, you know, home court situation.
Yeah, 100%, especially now with the globalization of IP in general. I mean, most things are cross-border by their very nature. So that's a super important point. Well, any other last words about IP arbitration?
Well, I think I'll only say this, that, you know, I think it'd be great if a lot more IP cases were to go into arbitration. I do think that it's underutilized as a process for resolving these kinds of disputes. One of the problems, of course, is that arbitration is a creature of contract, and therefore it's unlikely for two people who are strangers to each other, which is a lot of what IP is, right? In the court system, it's a patent, for example, owned by a patentee that really doesn't know the infringer or the alleged infringer. So arbitration has some limited circumstances where it may be applicable because there's already an underlying contract between the parties. Either it's an employer-employee contract or a commercial contract between business entities, or so maybe a licensor-licensee situation. But without that prior relationship, it's unlikely that once a dispute has arisen, that the parties will, I mean, it's not impossible, but it's unlikely that the parties will agree all of a sudden, I'm just going to give up everything I know about the court system and just enter into an arbitration process.
Yeah, I mean, that's the whole kind of post-dispute arbitration agreement debate, right? You know, you think, well, if it's good for you, you'll agree to it after the fact, but not so much. Usually once disputes have erupted, but hopefully though, once, you know, counsel explains the costs and the benefits, there'll be more post-dispute IP arbitration agreements.
Yeah, but I think if you are trying to sort of live up to the promise of arbitration, being cost-effective and expeditious, you know, IP is definitely an area where you could get some benefits here by actually invoking that process, because there are some tremendous cost savings and time savings by using this process.
100%. Well, thank you so much for sharing insights with us and taking your time today. I really appreciate it. Really good, important stuff, good things for all of us to think about. So thank you.
You're welcome. Thanks for having me.